All right. Oh, hey, everybody. We are live. Thanks to the FPF team for putting us on the air. And thanks to all of you who've joined me and today, Stacey Gray, our lead on legislation, federal and state. For those who don't know, I guess you have to know, you're on my page. So I guess you do know that I'm Jules Polonetsky, CEO of the Future Privacy Forum. Delighted to be with you here today. Stacey is joining me to talk about probably the most challenging issue, although all the issues of getting federal privacy legislation are complex and complicated, but certainly one of the thorniest procedural issues after we deal with the merits, although I think it's hard to pull apart procedure and substance, as many groups have argued. But more procedural is the issue of should proposed federal legislation preempt state and local legislation, fully preempt, partially preempt, field preemption. It's actually pretty complicated, and we're going to talk about it. We'll also talk a little bit about the other hot issue, of course, private rights of action. When do you get to sue? When should class actions be feasible? Obviously, for corporations, that's the scary thing, because you can have multi-billion-dollar judgments. We've seen some of those already under the Illinois Biometric Act, where Facebook, settled at huge costs. So, but there are dozens, many lawsuits under that Illinois Biometric Act, and so you've got folks who worry that perhaps huge liability for things that are maybe more minor. I guess we shouldn't argue in any way against huge liability for big and bad things, but there's certainly been some history of different levels of litigation, some of which have primarily helped lawyers more than the people who may have been harmed. And the recent Supreme Court case in TransUnion that really added some important limits, and that really could affect the politics and the legal issues around how one might do enforcement. So Stacey posted, was it last week? You'll see it on our site, a really thoughtful piece about how one might look at about a dozen state laws and a dozen federal laws, and how they handled preemption to start coming up with some theory to help policymakers, critics, all of you who are thinking this issue through with some of the nuance. So let me start there, and I'll just note that she's about to post at some point today or Monday, so keep an eye on our site, a follow-up to that starts to go into even further analysis. So Stacey, over to you. You want to perhaps talk about the memo that you posted and some of the interesting ideas that help frame the conversation?
Sure. Thanks, Jules. That was a great introduction. I mean, this is probably one of the most complex issues that I've encountered in 5+ years of working in consumer privacy. And I agree with you on the initial point that I think most advocates and business representatives are justifiably not always willing to talk in detail about preemption or enforcement without talking about the substance of the law first. Obviously, that's the bigger issue. But that said, assuming we can reach a compromise on the substance of what a federal law should look like, the question of preemption is something we're also going to have to figure out in order to reach a compromise, because there's so much polarization on this issue, and because it's so central to the role that a federal law should play. So first, I think the two often get conflated, preemption and enforcement. They're not at all the same thing. Preemption in US law just means that federal law in general will supersede state law when the two conflict. Comes directly from the US Constitution, right? So if there's a conflict between a federal and a state law, the federal law will win the day, so to speak. Beyond direct conflicts, though, there's a whole world of when is a federal and a state law, when are they inconsistent? When are they just different? When does a state law go farther than the federal law or raise the bar higher for data privacy? And within that world, really, it's completely up to Congress. congressional intent is the touchstone, so to speak, on preemption. They can do whatever they want, from not preempting state laws at all the way to the other end of the spectrum, where the federal government establishes a complete dominance of a field, which they've done in things like airline regulation or immigration enforcement, for example, in most cases, right? So where the federal law just completely dominates the field. So how do we figure this out for data privacy? There are hundreds of state privacy laws already on the books in the United States, from common law and generally applicable laws to the comprehensive or non-sectoral laws like the CCPA and the Virginia and Colorado laws that were just passed in the last few months, but also laws like CalAPA, the California Shine the Light Law, just hundreds of laws on the books. And I think most people don't think about those. They're just thinking about the CCPA, right? And there are also a wide range of existing federal privacy laws already on the books. What we did is we surveyed 12 of them, just starting with the sectoral federal privacy laws that have been passed from the 1960s to 2003, from the Wiretap Act to CAN-SPAM, which is our federal law around commercial email marketing. And we took a look at the extent to which each of these federal privacy laws are preemptive or not preemptive of similar state laws. And it was a really useful endeavor. We posted the results in a discussion draft on the blog, have some really interesting takeaways. The biggest takeaway is just that this is not a binary issue. We often see Democrats and advocate organizations on the left saying, no preemption whatsoever, no preemption or floor preemption.
The states are the laboratories of democracy.
Laboratories of democracy. States should be able to increase privacy protections, right? A lot of that comes from the fear, I think, that the federal law will not be strong or will not be strong enough. So we might have a weak federal law that wipes out state attempts to go farther and be stronger. That's a reasonable fear, I think. And then there's the state laboratory of democracy angle. And on the other side, you see the business community arguing for essentially full field preemption. State can't pass laws at all, right? Or if it's around data privacy, that's probably not going to work either, just because of the variety of existing state laws that we have on the books.
There are the so-called, we try to avoid the term revenge porn. A lot of people know it, right? The non-consensual sharing of images, right? States have been moving to say, wait a second, you have some rights if someone has shared a photo like that, right? Is our goal to preempt that sort of thing, or data breach laws, or right? Yeah.
Data breach laws, data disposal laws. There are state laws that are narrowly applicable. For example, state laws that prohibit employers from requiring people to share their social media passwords. Or what do you do with state laws like that, right? There are library records laws. Another big thing is there are a lot of state laws that supplement federal sectoral laws that are themselves not preemptive. So our healthcare laws, the federal law is HIPAA, and HIPAA is not a preemptive, generally speaking, federal law. And so there are a wide variety of existing state healthcare laws, including California CMIA, lots of laws that require stricter standards for healthcare records or extend the protections of HIPAA to other types of businesses that are not covered by the federal law. And this creates kind of a silo in healthcare and finance, for example, where there has grown this large industry of compliance and privacy expectations and lock-in, so to speak, where it just wouldn't make sense if we passed a federal comprehensive law and it preserves HIPAA, which it almost certainly will. It wouldn't make sense to wipe out the state laws that supplement HIPAA, right? So at least within sectoral silos, it makes a certain degree of just common sense to preserve those. And that's not a widely principled thing. It's just a compliance practicality issue. So yeah, lots of lessons to be drawn there.
Maybe we should say, for the folks that are international or not in the weeds, it should be understood that the federal government doesn't simply get to, in the US, legislate at the federal level. The states are the ones who have sort of the intrinsic sovereign authority. However, in a number of areas where the Constitution gives the government the right to be the lead or be the exclusive, or decide whether to be the exclusive right or not, and many interstate commerce related activities, like much of this, presumably if you thought through some way to just regulate solely activity in your border in something that somehow really didn't affect interstate commerce or was tied to some very local function, maybe that would be beyond the scope of federal legislating. But generally, the Commerce Clause that allows the federal government to act when something affects interstate commerce, which even some very local commerce does. So that's why the federal government can act here, and why, in theory, it can preempt many of the commercial related laws. But there may be some that are related to schools. Education in the U.S. is a very locally regulated, area. We should note that the federal government sort of butts into some of those areas, even where it doesn't have the authority to regulate, by simply saying, well, you want money for roads or schools? Here are the terms. You need to follow this rule. And so there are a number of ways where the federal government exerts regulatory influence. But technically, if you didn't want their money, you might go differently. So just a...
Yeah, totally. We sometimes see people raising constitutional concerns around preemption, and they're usually about exactly what you're describing, Jules, which is not really a concern about preemption, but a concern around federal government exceeding its enumerated powers.
And one point that we won't deal with today, but maybe we'll come back if you're interested, and some of the viewers are interested. We obviously have a fairly strong First Amendment right, and it's clear that there's some line of cases where if the data maybe is public, or if organizations, individuals, or companies have a right to say something or have access to knowledge, there may be First Amendment speech limitations. But there's some academics who've really been arguing that that's not absolute, that even with strong First Amendment views, there's there are lots of ways to regulate commercial speech. Daniel Citrin has written on this, and oh gosh, I'm forgetting his name. Neil Richards. Neil Richards.
Yeah.
Neil Richards has done some really great writing on this. So maybe at some point we'll come back to that, because there certainly could be some limits on states or the federal government restricting some of the commercial pieces. So in your analysis, what are some of the other sort of takeaways when you looked at some of these laws? You said things like, there are clearly areas where there is, logic for the state continuing to act, and others where clearly a lot of the legislation intends to go and preempt the CCPAs, the clearly broad, comprehensive pieces. And then there's probably some debate over things like the Illinois Biometric Act or others that are not comprehensive, that targeted one issue, but certainly are in the realm of what general legislation would take. And then there may be harder and more complicated ones, like a lot of the states passed student privacy laws to cover commercial vendors to schools. And is that going to be?
Yeah, well, so in general, state privacy laws that govern state government activities are generally not going to be impacted by a commercial federal privacy law and its preemption effect. So if we're talking about like mini privacy acts, for example, which is what we might call the state laws that govern state agencies' collection of records, those are probably not going to be affected. Same with school district regulations for the most part. And I think the big one is state law enforcement regulations that impact privacy. So state law enforcement facial recognition bans are unlikely to be something that could be preempted by a federal law.
What about the laws that regulated the vendors to school districts, right? Not the school districts, but we had really two series of state student privacy laws. Ones that said, here, school, you can't do this, you can't do that. But then there were others that said, hey, if you are a cloud vendor or an ed tech provider, you may not do X, Y. It's obviously tied to the local, but it's regulating the commercial seller to the local.
Yeah, I think those sorts of laws could potentially be preempted or not preempted, depending on what Congress wants to do. And if they were impacted, the school district or the school or the local government could probably enact those same protections just in a different way by regulating the school or the school district and what kinds of contracts it can make with vendors.
Where we saw this dance? You remember the COVID app-related bill that Senate Commerce staffers had worked on and put out, where the concern was the apps that were going to be used for digital contact tracing, right? And these apps were being offered by state departments of health. The federal government could not directly say to these state departments of health, here's the rules for what you can or can't do with COVID apps, but they sought to regulate the vendors of the technology who were selling and building this stuff for the states and saying to them, here's the requirements on you. Now, I don't know if that would have worked at the end, because you're basically telling the vendor what they can or can't do with the state. That means the state can't buy it. So it really might have been an end run that might not have worked. And this might actually be the issue with some of these student privacy laws as well.
Yeah, exactly. I think it's a perfect analog. Yeah. And generally less about preemption and more about the federal government's powers in the first place, to regulate.
Now, you've done a second follow-up to the first memo. And the first one, like we said, you took a cut at, let's look at 12 statutes and see how they preempted, how they didn't preempt, and what that looks like, so that we can take some lessons for federal bills. And I urge people to take a look at it. But you are shortly going to post a follow-up, and you took a different tack this time.
Yeah, so the other way I think to approach this is to start sort of, instead of from the top down, to go bottom up and look at the existing state laws that are on the books. And so my goal with this post really was just to demonstrate that the conversation is so much broader than just talking about the CCPA or the new Virginia law or the new Colorado law, that there are hundreds of state privacy laws on the books. And there are really two ways to think about these. The first is to think about them through whether or not they would be impacted by an express preemption provision. And the second way to think about it is whether they would be impacted, but you could preserve them through what's known as a savings clause, where they would be preempted, but the federal law has chosen to say, we expressly would like to preserve such and such state laws. And so we see a lot of proposals that do this, that say, expressly we're going to preserve state UDAP laws, unfair and deceptive practices laws, state tort law, state common law, the privacy torts, right? And things like that. So that was our second approach. We found it to be just a very, very broad field of laws that people should take into consideration, and a possible way to reach compromise. Two staffers or lawmakers could sit down and just go through a list. Okay, well, what do you want the impact to be on social media password laws, or healthcare laws, or financial laws, right? What do you want the impact to be? And just kind of go down the list. So that was our goal with this one. We used a resource by Robert Ellis Smith, a compilation of federal and state privacy laws that I highly recommend.
Yeah, he keeps that up to date every year, and I know I have it on my shelf at the office when I head back. It's been a useful tool. Does he still print it? I know it's now digital. I think I have. I know I have printed.
Well, I don't have the printed. I don't have the printed version. I think I have it on Kindle and a PDF, but last updated, I think, in 2018. So it's not going to include some of these newer laws. But that's kind of the point. Some of these have been around for 50 years, right? And could be inadvertently preempted by a federal law. And that's what I think most people would like to avoid. So, I mean, more lessons, I think, from looking at the federal sectoral privacy laws, if I had to say. One of the other big takeaways Jules, for me, in addition to this just not being a binary question, is kind of looking at the history of privacy laws and the type and the nature of data being regulated by each of these laws. So my sense is that the more expansive we've become over the last 30 years with the type of data regulated in how we define personal information to include, identifiers and IP addresses and all kinds of pseudonymous online data, the more push there's been for preemption because of just the compliance issues across state lines and the nature of the internet. So just really briefly, the best example I found of that is sort of comparing and contrasting the TCPA, the Telephone Consumer Privacy Act, I think that's right, our federal telemarketing law with our federal email commercial marketing law. Really similar impulse. It's about unwanted commercial messages, one to residential phone numbers and one via email. Both of these involve personal information. Email addresses are clear PII, phone numbers are clear PII, but there's a big difference in compliance ability with between the two, in the sense that phone numbers and residential phone numbers, because this law was passed in 1991, residential phone numbers are pretty easy to tie to a particular state through the area code. So complying with 50 different state telemarketing laws might be costly, but it's not at all impossible. You can do it because you can pretty clearly automate that even and know where state phone numbers are coming from. Email addresses are kind of the opposite, right? Clearly PII, but nothing in someone's email address can tell me what state that person lives in. And if that's the only information that you have and it's not linked to a broader identity, then it raises a real compliance difficulty of being able to comply with different state laws, one requiring opt-in and one requiring opt-out. So to me, that's a very useful lesson for our current debate, at least with respect to some types of data.
Although it's interesting, one of the key issues that a lot of the state laws are capturing is cookies and ad targeting and the sale of data via delivering ads and creating profiles and sending those into third-party exchanges and so forth. And states are doing that state by state. There is some ability, obviously, to geo-target and to determine what state you're coming from, but not necessarily with the highest of accuracy. It's not like there's a state border, on the internet. These are done typically by looking at IP ranges. There are third parties that sell information about, where different IPs are. I mean, you might be coming in from IBM headquarters, and it's obvious where that particular building is. But a little trickier with mobile plans, for instance. The IP addresses there are sort of handled by the carriers, and their plans are not necessarily going to track state borders. Apple is increasingly going to be running your traffic through, I guess it's not formally a VPN, but a VPN-like system. If you are a customer of iCloud, if you don't pay anything for extra iCloud, this is not going to cover you. But if you are one of the many millions who pay for extra storage or some of the other iCloud Plus features, your traffic will be run through. I don't know yet whether you're going to have to make a choice or whether that's sort of automatic, but run through sort of a intermediary where what sites you're visiting and what IP you're coming from. Now, Apple is going to provide some degree of location, and it looks like it certainly will be at least the state level, from what we understand. They haven't been highly specific about that yet, but they've said that it's intended to allow, copyright issues where maybe music has been licensed in one country and not in another, and all that sort of thing. So it's still going to allow some degree, but not enough to track exactly, where you are. Ben Isaacson, a longtime privacy expert, CPO consultant now, flags that there was an interesting case just recently that didn't get a lot of attention in the privacy community, but is a really interesting case. And this was a DOJ action on, they announced it on World Elder Abuse Awareness Day. and they filed against companies that were involved in selling lists of vulnerable seniors that were then subject to various bad marketing schemes and really swindled seniors out of money, and there were some very big settlements and substantial dollars paid, and then points out that this was sensitive data. It was seniors who were vulnerable, so worth taking a look at. He's posted a link to the case, and it may indeed have some implications for what is sensitive data under these definitions. Let's talk for a little bit in the couple of minutes we have left about the TransUnion case, which was well, let me let you describe it.
Sure. The TransUnion case is sort of a follow-on to a series, a long line of cases, including one called Spokio, but others even before that, interpreting a constitutional requirement under Article 3 of standing, which is all about what is required in order for an individual to be able to sue successfully in federal court. So in order to bring a lawsuit in federal court, you have to show that you meet federal standing requirements that require you to have suffered an injury in fact that is concrete, non-speculative, that was caused by the violation that you're alleging, and would be redressed by a successful outcome in the lawsuit. And this is basically to avoid federal courts not issuing advisory opinions. There has to be a real case or a controversy there to be able to sue in federal court. But one of the biggest issues in the last 10 years has been whether, what kind of harm is harm that is sufficient to bring a lawsuit. It has to be non-speculative. It's got to be concrete. So financial harm almost always counts. But what about reputational harm? What about other kinds of harm? What about privacy harm or dignitary harm?
A good example for those of us who are worried about international data flows is the challenge of whether or not Europeans can get redress. Could Max Schrems say, the NSA has my data, I am harmed, and so I want to sue? And we've got a line of cases where the courts have said, no, just because you think you might be in an NSA database and you don't like being spied on, or the level of bulk access, and that's made it hard for us to guarantee that you can go to court if you're European or American and want to challenge surveillance.
Exactly. Yeah. So lots of cases like that. And in this particular one, in TransUnion, the plaintiffs were, the lead plaintiff was a man who had gone to a car dealership, and a credit report had been run against him to do a credit check. And in this case, TransUnion incorrectly matched him with a federal suspected terrorist database, and he was denied his access in that case, and later requested copies of his credit report, and they sent it to him. One copy didn't have the match on it, one copy did. The case was brought as a class action with a number of plaintiffs to essentially to challenge TransUnion's inaccurate matching of people to this suspected terrorist database. And the case holding kind of split it two ways. Oh, and I should mention this is all under the Fair Credit Reporting Act, which requires credit bureaus to take reasonable steps to ensure the accuracy of credit reports, right? And other procedural requirements. The holding in the case kind of split it two ways. It said, okay, if your information has been shared by TransUnion with companies for purposes of credit reports, and that inaccurate information was shared with others, then you have standing or a concrete injury to be able to bring a lawsuit. But if the information was merely inaccurate, even inaccurate in this kind of horrible way, but merely inaccurate, but hadn't been shared with anyone, then you do not meet Article 3 standing requirement to bring a lawsuit because you haven't been sufficiently injured in a concrete, non-speculative way. You haven't suffered any financial injury, you haven't been impacted, you haven't been denied a loan or anything else. The information hasn't been shared. So that's really interesting. The court confirmed that the sort of usual privacy tort-like injuries are still going to be sufficient to have standing. So reputational damage, for example, or invasion of privacy. But in this case, that hadn't been shown. So it's not a major change in my mind from prior cases, but it does kind of drive in the point that there are some kinds of procedural violations under FCRA and under a future federal privacy law that aren't going to be something that individuals can challenge unless they can show some additional way that they've been impacted or harmed. And inaccurate information is the best example of that. So that's a real challenge, I think, and impacts how lawmakers are going to think about how to draft a private right of action in a federal privacy law, assuming that a federal law has a private right of action. It probably can't be a private right of action that applies to any mere violation of the law. There'll probably have to be some additional harm shown.
In many ways, it might help get some consensus in that, to the extent that some may have had a view, hey, I want to be able to, I don't trust that the FTC is going to enforce it well, or that AGs, and we need enforcement. And this is a big issue for folks focused on the civil rights, implications as well, obviously, where there are concerns that algorithmic discrimination or other issues in the law will have a disparate impact on certain classes of people. And there's sometimes a long history of skepticism that unless you go to the courts, who have played a key role, for instance, in expanding civil rights, even when local law enforcement wasn't interested in protecting those rights. There's also on the preemption side and civil rights interest in some of these state laws that might be going further in helping protect civil rights, certainly facial recognition, although most of those laws have been government ones that are not likely to be preempted or affected, but that's certainly been an issue. So perhaps the fact that we will focus on what is harm will allow kind of and presumably the civil rights impact issues are those that we can analyze and recognize indeed do cause harm. But I think that's going to be an important area to understand, and whether or not someone got access or deleted or so forth might be harder to bring. We should note that this doesn't affect many of the state laws where state courts may allow easier access to a state court. But again, that complicates our preemption question. If we preempt it, we now lose some of the broader rights that someone might have had to go against a more dignitary oriented harm. Anyway, please take a look at the memos blogs that we posted on this. One is up, the other is going up in a bit. And we look forward to continuing to chat. So Stacey, thanks for really talking through these issues and for the really thoughtful work that went into this work. Our goal at FPF here is not to be, agitated about either extreme. We get that there are important and significant equities on every side, but to try to help everyone best understand the ideas, the challenges, so that when we all get to the table, folks can be most informed, and we can hopefully get a federal privacy law sooner than later, and certainly one that is strong and effective and will stand the test of time. So thank you for your work, and thanks everybody for listening along. Have a great weekend. Happy July 4th for those who are celebrating like us.